So, Olivier, thank you very much for agreeing to take us out of today on a high note. It is very kind of you to just make it here in a way at the latter part of the day. What I would like to do is really hear from you a number of thoughts. The day has been varied and diverse. We started in the morning with a big picture sort of angle. We heard a lot of voices from the US talking about reinvigoration of antitrust, the change in the underlying political economy, which we're all aware of, drifting into industrial policy, subsidies, and all that, the interplay between the US and Europe over there. And then we moved on to talk about more specific areas from merger control to digital. Why don't you take it away and start with your thoughts at the end of this day? You weren't here all day, but I'm sure that you have a sense for what was discussed, and then we can back and forth.
Well, I listened to the whole of the last panel, and I connected when I could during the day, and I had spies the rest of the time, so that should be okay. Well, it's difficult indeed to wrap up such an intense day in just a few minutes. So I thought I would pick three themes that were intensely discussed today. First, this interplay between industrial policy, competition policy. It's not that it's really new, but it has a renewed interest today. Second, the DMA, a lot has just been said, but maybe I was interested by the duck example, so I may elaborate a bit more on that. And thirdly, the challenges in merger control. So maybe to start with the first point, so you see, I took notes. So in the end of the day, well, let me put it this way. In the last 15 years, we've been through 3 crises. Each time we were told is the crisis of the century. And they actually were. I mean, the financial crisis was not exactly a walk in the park. Biggest crisis since the Great Depression. The COVID crisis, pretty much unprecedented since the Middle Age. And now we have in Europe at least the energy crisis, and which has some similarities with the financial crisis, because energy and finance are really the blood of the economy. So if you have a problem there, you have a problem pretty much everywhere. And in this time of crisis, of course, for any policymaker, and competition policymaker are no exception to this, the issue is how do you reach your long-term objective and at the same time meet your short-term challenges without disaligning too much from your long-term objectives. The long-term objective have been recalled by Margrethe this morning. I think there are 3. We want to achieve decarbonation and net zero by 2050. We want to manage successfully the digital transition, and we want to build a more resilient economy without too many other reliances. We're comfortable with interdependencies, but what the COVID told us is we had some spots of other reliances in very strategic products, chips, for example. And this is basically where we need an industrial policy, because if you think about it, these 3 things are probably the 3 pillars of any industrial policy, and very relevant to any competition policy. And competition policy, for a long time, the neoliberal paradigm in Europe was that we have an industrial policy, this is our competition policy. I think that's a fundamental mistake. Competition policy should help managing our industrial policy. I think it can be a great help, because if you think about it, take resilience, for example. Well, resilience in many, many cases, because we will not onshore in Europe everything we need to produce in Europe. So resilience is mainly about diversification. And guess what? Competition does quite good in diversifying. But sometimes you will need to ensure. And there, of course, you can do it with state subsidies, and sometimes you will have to do it through state subsidies. But it's a quite expensive way to plug for your deficiencies in setting the right framework conditions for these activities to take place in Europe in the first place. So, and this is what industrial policy is about. Industrial policy is not about pouring tons of public money on companies. It's about setting the right framework conditions for it to be interesting for companies to operate in Europe because they find it profitable, because this is where the future growth is, this is where the skilled workers are, this is where capital is accessible, etc., etc., etc. So competition policy can help in that, but competition policy cannot substitute for this. The second thing I was interested in was the DMA. So a lot was said by the panelists in the previous panel. When listening to the duck example, you know, I was thinking of my friend Martin Snoop on his Chicken of Tomorrow. So it's the duck of tomorrow in a way that you want us to shoot. But you know what? Antitrust is about the duck of yesterday. And it cannot be anything else. Because otherwise it's not that you're shooting the duck of tomorrow, it's a Minority Report. So you put people in jail before they have committed any infringement because you suspect strongly they will. And that's, well, as an enforcer, I would love a system like this, but this is not the system we have, and I suspect this will not be any sooner the system we will have. But yet, I mean, I think it was clear in the latest intervention. The great thing, I've been a regulator for the last 10 years, between 2010 and 2020. And regulation is really about trying to create a gymkhana for firms to do what you think is desirable. That is what regulation is about in the end of the day, to force them in their profit maximization strategy to do the things that you think are good for the greater good of people. And in a way, this is what we're trying to do with the DMA. We're telling them that these are areas you cannot go to. And we hope they will somehow police their behavior and go where we want them to go. Of course, you may think, well, then they will try to profit maximize in other ways. That is quite likely, actually. And this is why Alberto, I think, very rightly suggested that the DMA is not the end of antitrust in tech or in the platform economy. Because for sure, the platforms will try to pursue different profit maximization strategies while trying not to infringe too much the DMA, which likely will create a new generation of Article 102 cases. Or at least it's not impossible, and we should be prepared for this. So I think the most interesting part in this whole saga, above and beyond everything that has been said about the next steps in implementing, all this is very important, but is what is going to be the interaction between DMA and 102 going forward once DMA is in cruise speed and is being implemented? That I think is really the €1 million question. And the interesting thing is, and that's why we have Filomena and her colleagues, and we have Alberto, is the DMA really needs to be coordinated both ways. It is to be coordinated with the rest of the regulatory framework. It is not something that is out of the rest of the regulatory framework. And it needs to be very strongly coordinated with the rest of antitrust, and in particular the colleagues in national competition authorities. And this is exactly why the co-legislators have enshrined the coordination of the DMA in the EC, and I think that's very important. And my last point is on mergers, and this is the panel I could listen less to, But I think that there are 2 points I'd like to raise. The first one is obviously Article 22. As you said it, Christina, most of the day was about innovation. And you see it in merger control, you see it in antitrust. Our theories of harm are more and more innovation theories of harm, because more and more this is what defines competition, and not only in tech. That means in tech, but also in pharmaceuticals and maybe in other sectors, what defines the competition of tomorrow is actually transactions that are below any possible radar screen in terms of thresholds. And this is exactly why in many jurisdictions, in the UK, Andrea is here, in the US, they don't have this kind of very clear and predictable framework. It's more flexible, or patchy, depending on how you judge it. But there is the flexibility to capture the transactions that matter. But certainly, having a hypothetical world in which you would have a zero threshold for transaction, which means we will be flooded by notification, and the firms will have a huge burden for any transactions, that's not the situation. So I think having changed our recommendation and not reinterpreted, Article 22 was really the most economical way of reaching that result, because the burden on firms is minimal. Mrs. Vestager announced that in September 2020. How many cases have we taken under this new recommendation since? One. Illumina. Well, I grant you that if Meta customer had not been notifiable in Austria, we may have taken it under the new recommendation as well. But it happens that it was notifiable in Austria, and therefore it is a old school Article 22 case, and so is Adobe Figma. So we're talking about something, the number of occurrences is really low. To be frank, for any decent practitioner, it's not terribly complicated to predict whether a case will be a potential candidate or not, so it's not that you have a terrible burden on firms. For me, it's a quite effective way for Europe to be on par with other jurisdictions in the world that have a much more flexible and therefore, in certain respects, demanding for firms system. The second point I'd like to touch base on challenges in mergers is remedies. And there I think my views are relatively close to the views of my friend Jonathan Cantor. I think we should be, and we're trying to move the policy in that direction for ever since at least I'm in this office, towards being a bit more rigorous in the way we implement remedies. I've been sinning a lot. That's the problem when you're in this business for a long time. You have a past, so I have accepted merger in airlines with slot remedies. So if you look for responsible for the monopoly route between Brussels and Basel, it's me. We have accepted this remedy back in 2000-something. I say Philippe Lowe, I don't know if you have a better recollection than me. But with slot remedies, as far as I know, the slots are still there. And it is a Lufthansa, Brussels Airlines, Swiss monopoly. And I have accepted remedies in industrial cases in which you would unscrew a production chain here, a production chain there, you package it with a bit of an existing company, and whoops, this is your remedy package. The problem with this type of thing, it may work, but is very, very, very dependent on who is the buyer. So you take risks, and I don't think we should take risks. So I'm not to the point, I think Jonathan and his colleagues are saying, well, we prefer a prohibition than a bad remedy. I think we should avoid this type of bad remedies and be a bit more demanding on the parties, even if that means sometimes selling more than the overlap. And I think that's it.
Well, this is, just on this last note, you said I was there. Well, I kind of was there too. I remember those. And I think I refer to something that Andrea Coscelli, sitting in the front row, sometimes says. One is on a journey, right, through things. And what seemed to be adequate 15 years ago has proven not to be anymore. It wasn't as if there was bad will, but it has become apparent that these kind of gerrymandering of remedies that were done to divest and overlap, etc., ultimately haven't worked. So you're not where Jonathan is, okay? The CMA, we know, for example, is very reluctant to accept behavioral remedies favor structure, so do you. But how do you see it? That's my last question. Where would you see this sort of a more desirable position to be in terms of remedies? So we don't do those slot remedies anymore. We don't do like sell a plant and transport the line somewhere else. What is then going to be the focus?
Well, I think I'm a normal merger guy, so I don't like behavioral remedies, of course. But on the other hand, I have to implement EU competition law. And in EU competition law, you have equally to motivate why you clear and why you prohibit. And if you have a behavioral remedy that does the job, or at least you cannot prove it doesn't, it's quite demanding and difficult to prohibit to court standard in our jurisdiction. And maybe it's not so bad because I think this device is a bit artificial. I mean, let me take Google Fitbit, so data silo. The Commission has been widely criticized for this, even by peers that had authorized the transaction. But okay. But I still think this kind of, I would label it quasi-structural remedy, is better than clearing it, and I don't think we could have prohibited it because that remedy was not completely structural. So in other words, I'm not a lawyer, so like you, I suppose I don't think in black and white, and I don't think this issue is any more black and white than any other. There is a continuum in remedies, from the purely behavioral, and I promise I will not abuse my dominant position, you don't want to see that, to the completely structural. And there is a wide range in between, and in particular in the digital economy, where you have to balance advantages of the mergers, disadvantages, and the fact that disadvantages are pretty much well counterbalanced by this kind of, I mean, sort of idiosyncratic to the data economy remedies.
But there is something I need to ask, sorry, and that's going to be the last question. Yes, it wasn't the last, this is the last. So you said what is actually standing in the way for us is that we have to meet the same sort of standard when we are not accepting a remedy if it is available and it could have done the job relative to when we prohibit. And this goes into the discussion we were having this morning. I mean, this is the kind of concern that, legitimately you've had forever. If we accept a remedy, does it do the job? Does it not do the job? At least in our view today. But isn't this the time, or isn't there an urge to just push it? And so to say, well, these kind of remedies that we've accepted in the past have nonetheless come together with concentration of markets, which has not really been a great outcome. And so, okay, I may be at risk of being challenged or losing in court, but this is the time to take those challenges, which I understand is the position that Jonathan is taking, that FTC are taking in a way. We are going to just push it and see.
Well, how to put it? if you look at the way merger control was enforced in the EU for the last 20 years, or even 30 years, and the way it was enforced in other regions of the world, we were even criticized for, at times, for being over-enforcing. I always thought we were slightly under-enforcing. But let's say that others have been more under-enforcing than we. And there is therefore a greater need for correction, arguably. And that reflects in the data on concentration, which are worse in Europe than they were, but the degradation was less than elsewhere. So, all in all, we certainly could have done a better job, but we didn't do that of a bad job. So the need for correction, I'm not sure is so big. Second, I don't see the legal standards, as you suggested, Christina, as an impediment. I think it's actually good that we have this obligation to reason with the same standard an authorization than a prohibition. And therefore, we're forced to ask ourselves whether the remedy does the job. Again, for me, between a good quasi-structural remedy and a structural remedy, which sometimes do not exist. Google Fitbit, this animal did not exist. Is that the quasi-structural remedy requires monitoring. And the reason why, fundamentally, all enforcers hate it is that it mobilizes for a long time resources that you do not have anymore to continue to enforce. That's the biggest problem, frankly, with when the remedy is good. When it's bad, you should simply reject it. But when it does the job, there is no other structural alternative. Then, in the end of the day, the downside for you as an enforcer is it will eat some of your resources. But that's not the legal test, and that's not the concern of the judge. And I don't think it should be, to be completely clear. So sometimes that means we will still have to live with this type of remedies. I'm not ashamed by Google Fitbit. I think we were right to do it, and I would do it again.
Well, on that note, I think we should all thank Olivier Guersent for his time and insight. And kindly proceed to get a drink at the end of the room. Thank you so much for the day.